Hey everyone, welcome to the Bold Inventor Show. I'm JD Hoovener, your host. I'm a patent attorney, but on this, just to make sure I have the disclaimer in here, I'm not your attorney, we're not your law firm at this point. Let's talk patents out of the gate. So a patent, what is a patent? Patent is a federal right, federally backed right that an inventor gets when they say what they've invented, when they tell the world the nuances of what it is that they have invented. So it has to be the first of its kind. It has to be a non-obvious invention and has to have utility. So if you do that, write down the claims, the scope, the metes and bounds of what you've invented, get it through the patent office, meaning the examiner does their own search, and you say, yeah, you prove it to the examiner that what you've got is first of its kind, is novel and non-obvious, you get a patent. So for a utility patent, it's 20 years from the date of filing, from the date of when it will expire. So it's 20 years that the US government is going to guarantee that you're the only player, the only one in the market able to make, use, or sell your invention. Now, there are what's called a design patent. A design patent covers just the ornamentation, just the way that it looks, right? Like this water bottle, just the shape of it, not the fact that it has functionality up top, but it's just the way that it looks. So design patents, all different types of things, hats, clothing, right? Any article of manufacture can be eligible for a design patent. Those are good for 15 years after the date of issue. So there's two major types of patents. All right, second major area is trademarks. Trademarks are, like you see behind me, bold patents, right? Logos, word marks, symbols that, yes, I'm in business and selling a good or service, and I want this to designate the goods of where, or the services of where they came from. So really that's it. It's a point of origin. So you know as a consumer where those goods or services came from. The cool thing about federal trademark protection is that if you're able to provide the right evidence that you've been using that word or that logo or mark in commerce, and you're the first one to do it in your product class or in your service class, then you can get a federal registration, meaning you're the only one able to use that in the whole country. That's a big deal, especially given today's technology. Probably in most cases, you're going to be selling internationally, right? All over the world, online. And so you want to have protections in every state of the country of the United States. So beyond trademarks, there's another category of copyright law, whole nother category, right? Copyright. This is what protects artists, creative works, books, paintings, up here, I got it backwards, songs, performing arts, right? Fine arts. This is music itself is a giant subcategory within copyright law. Now, what's interesting about copyright law is there's a little different rule. As soon as it is fixed, as soon as that painting is done, as soon as the song has been sung, if it was recorded, right, captured, fixed in a means where it can be played back or somehow evidence, right, that it's in a tangible means, you've got copyright rights immediately. There's no requirement to go register them in order to get the right. So the first two I mentioned, patents and trademarks, you do need to be proactive in registering so that it's known by all, or at least all that want to go find out, that you've got protection. Now, copyright is inherent. It happens under common law as it happens. The cool thing about registering it is that you can then begin enforcing it. So copyright law will be taken to federal court. So if you want to go sue someone for taking your painting or copying your song, that's where you have to have that litigation is in federal court. Before you go file your lawsuit, you will probably want to make sure that you have that copyright registered at the Library of Congress. So it's not the USPTO, the United States Patent and Trademark Office, like it is for patents and trademarks. Copyrights are registered at the Library of Congress. Okay. The fourth, and we're doing great, we're making really good time. The fourth area of IP, in our IP 101 series today, is trade secrets. The trade secrets usually are kind of forgotten, right? There's actually, probably because there's no physical, document, right? Like you see up here, if you can see in the upper right, we've got a trademark, right? A registered trademark or a patent has the big ribbon on it. You're familiar with those those certificates. There's no certificate, there's no registration number for a trade secret. It's sort of Whether you have one or not depends on whether it is economically valuable, whether you're keeping it secret, and whether it's the actual information is not readily known in the public. So those three criteria will determine whether your company or you individually have a trade secret. One of the best tests for that first prong is whether if it got in the hands of a competitor, would they be able to go to market and have a competitive edge, charge more money, have more clients, get more information, right? And make their product or service more valuable in some way. So if the answer is yes, or probably, you probably meet that first criteria. So the second prong is actively keeping it secret. If you're leaving your trade secret information out on the public, or even arguably, available to all employees without any restrictions as to who has access to it, it's also probable that that is not meeting the bar of keeping it secret. Having things encrypted behind closed doors, physically locked in a safe, right, within a secret digital file that only a few people have access to, that would be reasonable measures for keeping that information secret. The third prong of the trade secret criteria under the United States Trade Secret Act is that it's not readily ascertainable. So the information must not be known in the public. But it doesn't necessarily mean that no one knows it, right? It's just that it's not readily known.